On August 9th, the federal court struck the claim with respect to the Bank of Canada. We had sought declarations with respect to the provisions in the Bank of Canada, and we'd also sought damages for public misfeasance and conspiracy between the Canadian government actors and international bankers. Now, this decision, I have to say frankly, is one of the most anemic and lilting decisions I've read in a long time. It's completely wanting in logic and in the application of the law. In a nutshell, what the court decided was that the court had jurisdiction to hear the case, that my clients had standing, they had the right to bring the case, both individual standing and public interest standing, and but that the claim was being struck because it was not justiciable. And what that means is that justiciability is a doctrine whereby a court decides that the matters are not within the scope or the expertise of the court to actually decide, which is the most puzzling, bizarre aspect of the decision, because once he decides the court has jurisdiction to hear it and that the parties have standing, then justiciability is a question of, has the court heard these types of cases before? And obviously the court had heard these kinds of cases before in terms of socioeconomic issues and banking issues. The Supreme Court of Canada has been dealing with banking since Confederation. And the Supreme Court of Canada dealt with things like the wage and price controls under the Trudeau years. So when the court decided that this is not justiciable, it really is a bizarre finding. And one of the reasons that the court finds it's not justiciable is that it finds that the Bank of Canada can refuse to give interest-free loans because the language in the law, in the Act, under Section 18, is permissive because it says may. Well, if you can decide that, then you just made it justiciable. I mean, he's decided the very issue that's supposed to be decided by... I'm sorry, what? So once the court decides that, the bank can do that, well, it's adjudicated. But the court on a motion to strike, according to the Supreme Court of Canada, can't decide that issue. It has to be for the trial judge. So we're caught in this vicious reverse circle, in this vicious reverse circular reasoning of the court saying it's not justiciable because I don't think you're going to win. Well, then it's justiciable, isn't it? And so what the court has done is really short-circuited the process and not allowed this to go to trial on very specious grounds. It simply doesn't hold water. And so we've appealed it. Notice of appeal was issued August 16th. We've heard from the court. They've scheduled the appeal down for December 10th at 9:30 a.m., Tuesday, December 10th of this year, 2013. We have to file our materials by October 18th, and the respondent has to file by November 8th, and so the matter will be heard for a full day in federal court at 180 University Avenue on December 10th. There's nothing much more I can say about the decision apart from the fact that it's simply illogical and it's contrary to all the jurisprudence. And I'm not disappointed that I lost. You don't win all cases. I'm disappointed that this is such as I said, is such a bizarre, illogical, ill-reasoned decision that's circular in reasoning and result-oriented.
Would you say it's possible that there was political influence on the judge to come out with that decision?
I don't know. I don't want to speculate about that. I doubt it. I think it's a combination of, I frankly don't know what it is. I plead that I don't think that the court understood, frankly, the arguments or the nature of the matter.
And do you think that the fact that the court turned it down the first time will have any outcome on the eventual case itself?
It's hard to say. Sometimes yes, sometimes no. I mean, the first level decisions are often overturned. And sometimes they're overturned more than once on different grounds as they go up.
Well, I've heard you say that very often it's a case of whether the court actually wants to hear it or not, whether it goes through. It's obvious that the court doesn't want to deal with this, And do you think that the fact that the court doesn't want to have to deal with it could possibly have anything to do with the outcome, or will the outcome of the case be strictly on the law?
Well, it's clear that this court official, this judge, did not want the case to go forward. He would not want to hear it. He's wrong in applying the law and his function. Is there a guarantee that the appeal judge or the Court of Appeal, the Supreme Court of Canada, will apply the law? No. Courts sometimes do not apply the law when they politically do not want to hear cases. If you're asking me, is this the case here? I'm saying it's too early to tell.
One thing I was wondering, I'm not sure if this came up at all during the case, but I was reading in the Bank of Canada Act, there's this part, I think it's 17.2, and it seems like they talk about the shares in the Bank of Canada, and it almost makes it seem like the Queen's the sole shareholder, or I'm not sure if that's the reading of it, but like, did that ever come up? Or?
Well, that came up in argument, but the shareholders are held in trust by the Minister of Finance for the people of Canada, essentially. We're the shareholders. We're supposed
So in other words, the Bank of Canada is not a Crown corporation.
No. It's a public bank overseen by Parliament and the Act of Parliament. It's not a Crown corporation. No. It's like the Defense Ministry or the Immigration Ministry, or it's a public institution created by Parliament. It's a public bank.
Well, there's been a lot of talk recently that one of the reasons why the United States and its allies are pushing for a war in Syria is that there's only 3 countries in the world left that are not on a standard banking system or a privately controlled banking system, that being Syria, Iran, and North Korea. Do you think that the banking system has sway over the democratic system in the Western countries?
It completely controls it. The banking system, we've arrived at a point in history where the bankers control the democratic process. There's no question about it. They control everything that trickles down. Finances controls every aspect of a capitalist system. It controls every aspect of any international trade deals. We're at a critical point there. The Canada-Europe trade deal that they're negotiating right now, we hear rumor that one of the big sticking points is that the Europeans want our public bank, gone. And that they want even the possibility of interest-free loans by a public bank to the government for its people taken out of it by treaty.
Well, therefore, does it not follow that since the banks control the government, that they also control the court system? Or do you have, as a lawyer, do you have more faith in the court system than that?
Well, on an extremely cynical day, I would say that there's some control, but my experience is that no, they don't have complete control over the court system, no. I mean, judges are human beings, and therefore they may be swayed one way or the other politically sometimes, and by their own belief system. They're appointed and they're chosen, and so their natural political beliefs may and do impact on their judgments. But no, I can't really say that the courts are controlled. The day I believe that, I would hang up my robes. There's no point in practicing law. But I don't believe that as of today.
Any other questions?
Can I ask you just just for the cameras, a quick elevator speech of what the case is about?
Well, basically the case is about the Bank of Canada under Section 18 allows the bank to give interest-free loans to the federal and provincial governments up to a maximum of 1/3 of their annual budget, so long as those loans are paid the next fiscal year. Those loans are interest-free. The bank has not done that since 1974, when they joined the International Bank of Settlement and the international banking system over in Basel, Switzerland, and that is at their direction. We say that that's an abdication of governing, and that foreign private entities are controlling our sovereignty, and it's unconstitutional. And so we want a declaration that provision has to be acted upon. And there's other aspects to the case, including the way they calculate revenue and expenses under the budget. which is improper and fallacious and misleading. That's another aspect of the case. And so essentially, it's a case that asks for a declaration on the applicability of interest-free loans to the government for human capital expenditures, such as hospitals, schools, roads, and whatnot. This provision of interest-free loans is how Canada paid its war debt earlier than any other country. It's how we built the St. Lawrence Seaway. It's how we built the Trans-Canada Highway, etc. The irony is that while the Bank of Canada is not giving interest-free loans to the governments under the law, it's practically giving interest-free money to the private banks, who in turn lend it to our government at going market rates, which is insane if you think about it.
Well, that's because Harper said he never bailed out the banks. It was the Canada Mortgage and Housing Corporation.
Well, we all knew that wasn't accurate. Yeah. Okay.
There's been a lot of people following this case and had a lot of interest. Is there anything they can do to help, either come to the appeal case or anything like that?
Well, I mean, they can follow. They can help in whatever way they deem fit. If they agree with their position, they can let their MPs know. They can do what people do to express their opinion or their support for any point of view or any cause.
What was happening in December?
The appeal from this ruling that struck the action as non-justiciable, we've appealed that. So on December 10th, the appeal of that decision that was just made August 9th will be argued in federal court.
I remember back when we first found out about the case, you said that they would do things like this. They would hold the case up and make it take longer. Do you feel that that's all this is a tactic to stretch it out?
Well, no, this is what they do. It wasn't as much the case 30 or 40 years ago, but it is now. The government doesn't want to be bothered with, independent judicial interpretation of citizens' rights. It just wants to rule. It's no longer interested in justice. Or is that not clear to anybody under today's regime? Yeah, anyway.
Okay, Rocco.
All right.
Thank you very much.
Thank you. Okay.